As an estate planning attorney that both helps establish trusts and administer them after death, an understandably common concern I hear is about how to handle outstanding debts. Is the trustee ever personally liable, and what if there just isn't enough money in the estate to cover various debts? But first, please be sure to like the video, subscribe, and ring the bell. Also leave a comment below if you have any questions or have a topic you wish for us to cover. But as always, thank you very much for watching. To begin, trustees are not personally liable for the debts of a trust, such as a mortgage on a trust property, outstanding loan from a promissory note, or even any medical or utility bills. You as trustee do not have to pay these bills personally. As one would likely guess, the trust itself is responsible for its own debts. The trustee's role is to manage the trust, not personally bankroll it. That means so long as the trust has cash flow, then those funds are to be used to address the trust's debts and expenses, with the trustee writing the checks. However, the complications arise when the trust itself doesn't have cash flow, either because the trustee has yet to gain access to accounts or there are simply not enough liquid cash in the trust, as the bulk of the estate is tied up in something else like real estate, for example. This is a case where we'll have to approach each situation a little differently. If the problem is simply that some regular bills are coming due, like a monthly mortgage or utility bill, but the trust has yet to gain access to the bank accounts with the cash in them, then the trustee can pay for those bills personally and receive a reimbursement for covering those bills. There are a few understandable reasons a trustee might not be able to access funds straight away, which mostly center around a trustee becoming trustee after the death of the prior trustee. In that case, the lag is usually due to waiting on a death certificate or waiting for banks or brokerage firms to get their paperwork in order. However, this situation is relatively easy because there are funds just not readily accessible yet. The true complications arise when the trust assets mainly consist of a house and a few thousand or even a few $100s in the bank. In a case where the only real asset is a house, yet there are ongoing bills and debts, a calculation will need to be done. Are the proceeds from the sale of the house going to cover the outstanding debt and still allow for some inheritance to take place? It is very rare, but we have seen cases where a house was allowed to go into foreclosure because there simply wasn't going to be enough money to cover all the debts, and thus the house was let go to allow the creditors to fight amongst themselves at that point. However, in most cases where there is only a house to speak of, the sale of the house will create liquidity in the trust estate. Essentially, converting the house to cash allows for the trust estate to have money to cover debts and reimbursements. That means a trustee or a beneficiary could pay ongoing necessary bills like the mortgage and utilities on a property and receive a reimbursement for those personally paid bills once the net sale proceeds from the house are paid to the trust. 2 points to keep in mind, however. A trustee has a legal duty they must follow when serving as trustee, and a trustee is not obligated to personally cover or guarantee any trust debts. To quickly address two relevant trustee duties, a trustee has a duty of care and a duty to safeguard trust assets. These are technically separate duties, but I consider the duty to safeguard a trust assets to be under the umbrella of a trustee's general duty of care. A duty of care is that a trustee is obligated to act with the same degree of care, skill, and prudence which would be exercised by a reasonably prudent person in managing similar property, and the trustee is under a fiduciary duty to act for the benefit of the trust and the beneficiaries thereof. Under this general duty, it is the duty to safeguard trust assets, entailing the obligation to preserve those assets, which the law considers keeping bills current as a method of preservation. Now, all that legal jargon simply means that the trustee is not obligated to be conservative, but to be reasonable when managing trust property, not take unnecessary risks, and above all, put the interest of the trust and the beneficiary above one's own. The trustee is not obligated to personally pay the trust debts, but they are obligated not to benefit to the detriment of the trust, such as buying the trust property below fair market value. Additionally, so long as there is a way for a trust to cover its own debts, a trustee is obligated to work towards making that happen, short of, again, personally paying, although they can receive a reimbursement for doing so. Click here to learn how to settle an estate in California, or watch this other video.